plaintiff's objection to defendant's motion for attorney's fees and request for hearing, and motion for attorney's fees pursuant Rule 60b4, 3 and d3. Comes now plaintiff Alyssa Montalbano and objects to defendant and alleged legal counsel's attorney fees and moves the court to deny any and all fees as fraudulently being alleged due the defendant and his unlawful and improper legal counsels, but plaintiff agrees to a hearing set and, in support thereof, states the following. See attached Exhibit CD for verbatim reading and visuals of this objection, and see Exhibit CE for Case 18 CV50 Timeline Key Events. Roman numeral 1. Key points of this objection in brief summary letters A through G. A. Relisting and inclusion of formerly filed documents available on this public court record in full legal and lawful support of plaintiff's contractual and legal claims against the defendant, James Corey Goode, and as seen restated in statutory counts and causes of action in the amended complaint filed August 2nd of 2019, and that should lawfully be the operative pleading in this case. See numbers 1 through 8, this document for details. B. The defendant, James Corey Goode, is legally and lawfully contracted with plaintiff Alyssa Montalbano since April 18th of 2018, and he has knowingly failed to perform pursuant to contract laws and is thereby obligated to pay plaintiff approximately $70,000 plus all damages resultant from his avoidance, evasion, defamation, and harassment tactics performed by himself, his attorneys, and associates since efforts at remedy were first implemented by plaintiff and pursuant his tacit agreement and estopple by acquiescence. CRS Title 4, Article 3, UCC, Negotiable Instruments. See numbers 8, 9, and 10, this document. C. Miss Wilde, alleged Texas attorney, has willfully and knowingly aided and assisted Mr. Goode in his criminal acts of fraud and has assisted him in avoiding, evading, and denying his legally due contractual obligations to plaintiff through Miss Wilde's knowingly participating in a malicious prosecution case in the Broomfield Combined Court and performing abusive process. She has knowingly failed to lawfully enter this case pro hac vice and address the matters at issue and claim on this court record in accordance with contract laws and due process of law. Miss Wilde has also filed multiple fabricated and knowingly misleading documents on multiple court records, notably to include a fake complaint on the Denver federal court record. She has committed fraud, violated contract law, and violated due process of law and her oath of office, and has legally and lawfully forfeited her right to any fees. See numbers 11 to 27, 36, 37, 41 to 48, 50, and 55, this document. D. Miss Liz Lurie, alleged Florida attorney, has willfully and knowingly aided and assisted Mr. Goode in his criminal acts of fraud and assisted him in avoiding and evading his contractual obligations to plaintiff through providing fake legal contact information while harassing plaintiff's witness under color of law. She has committed fraud, violated contract law, and violated due process of law and her oath of office to the state and national constitutions, and has legally and lawfully forfeited her right to any fees. See numbers 31 to 36, 50, and 55, this document. E. The defendant, Mr. Goode, publicly claims having mental health illnesses of dementia, aphasia, CPTSD, epilepsy, and brain trauma. All of these need to be legally investigated and addressed along with his well-known public claims of being in the CIA's MKUltra and MyLab programs. These are CIA mind control, personality splitting, and brainwashing programs, and these must be legally investigated to see if they are the source of Mr. Goode's deceptive trade practices, lack of memory, i.e. consistent lying on and off court records, and if they are the source of his publicly abusive behaviors and alien bluebird hallucinations. See numbers 6, 17 to 23, 28 to 32, 38 to 40, and 46 to 51, this document. F. This court's severe lack of case interaction with the legal contracts and injunctive relief matters at issue for almost 2 years since case implementation on June 25th of 2018 and its ongoing ignoring of massive amounts of evidence on this and multiple other court and public records in full support of plaintiffs' claims, and its ignoring contract law, due process of law, and having bias against the presumptive contractual matters at issue to include the CIA's mind control programs and associated situations, has caused additional and severe ongoing and repeat damages to plaintiff personally, professionally, financially, and emotionally, along with causing further egregious damages to plaintiff's public and private reputation, notably through the unlawfully issued dismissal orders issued January 29th of 2020, completely devoid of due process of law. See number 42, Applicable Constitutional Laws, number 52, Due Process Rights, and section 11, this document. G. Summary. The dismissal orders issued January 29, 2020 were issued completely devoid of due process of law and in clear violation of plaintiffs' constitutional rights, and the orders are in direct opposition to the presiding officer's oath of office to uphold said rights. See numbers 5 and 7, this document. The defendant, Mr. Goode, and his alleged attorneys, Ms. Wilde, based in Texas, and Ms. Laurie, based in Florida, have both knowingly assisted Mr. Goode in fraud and placing fraud upon multiple courts since Mr. Goode became aware of his legally due contractual obligations to plaintiff on or about April 20th of 2018. See number 9 below. The ongoing damages caused to plaintiff by the defendant and his associates' nefarious avoidance and evasion tactics employed for almost 2 years now, coupled with this court's repeat and ongoing failures to address the contracts and other legal and lawful matters at issue through its blatant denial of facts, law, and evidence, have caused repeat and ongoing damages to plaintiff. These damages can only be remedied by the court voiding the unlawfully issued January 29, 2020 judgment and addressing facts, law, and evidence in this case and is filed on this public court record and that cannot be legally or lawfully denied, and in so doing must accept the August 2, 2019 amended complaint as the operative pleading and must order Mr. Goode to address and or perform the legally binding contracts and presumptive pre-litigation affidavit complaint agreement. And the courts must immediately issue plaintiff the injunctive relief sought since June 25th of 2018, and this court and all presiding officers must follow due process of law from heretofore, and in so doing, they must properly move this complex case into legal discovery and toward trial by jury for lawful resolution of all matters at issue so triable. The following pages are detailed accounts of the above summary statements, letters A through G, with supporting fact, law, and even more evidence, and that are public record on this court record, other court records, and other public records, and that cannot be legally or lawfully denied by any honorably presiding judicial officer and honorable court of law. Should this court and presiding judicial officers continue to fail in performing their judicial duties and responsibilities to address the contracts and other injunctive relief matters at issue, this claim will be brought before the Supreme Court on grounds of such constitutional violations, and in particular the severe and ongoing due process of law violations taking away plaintiffs' inalienable constitutional rights for about 2 years now, and such acts are in direct opposition to an oath of office taken by any presiding judicial officer to uphold said rights. Roman numeral 2. Relisted formerly filed documents in full support of plaintiff's legal and lawful claims. 1. For the reasons stated in motion to deny attorney fees due to defendant failure to file within 14 days, filed on February 18th of 2020, and are incorporated by reference in this objection as if set forth fully in this objection herein. 2. For defendant and legal counsel's failure to confer in any way regarding their motion for extension of time for their failure to confer on plaintiff's motion to deny attorney fees due to defendant failure to file within 14 days, filed February 18th of 2020, and for their failure to confer on defendant filed motion for attorney fees and request for hearing, and failure to confer on defendant motion for attorney fees, both filed on or about February 26th of 2020, and for Mr. Goode and his improper counsel's regular, willful, and repeat ongoing failure to confer on motions and follow due process of law. The Honorable Dispositive Federal Court Judge, Judge Moore, did not tolerate this attorney abusive process and misconduct, and this court is expected to address this situation as well. See Exhibit BZ, Federal Court Register of Actions, at Docket 44. 3. For all the facts, evidence, reasons stated in the amended complaint filed on August 2, 2019, along with plaintiff's motion for preliminary injunction and affidavit Alyssa Montalbano and attached exhibits, and are incorporated by reference in this objection as if set forth fully in this objection herein. 4. For all the facts and reasons stated in plaintiff's objection to renewed motion to dismiss for failure to state a complaint, filed on June 10th of 2019, and are incorporated by reference in this objection as if set forth fully in this objection herein. 5. For all the facts, evidence, and reasons stated in the motion to void judgment pursuant Rule 60b3, 4, and d3. Filed on February 12, 2020, an attached affidavit and exhibits are incorporated by reference in this objection as if set forth fully in this objection herein. 6. For all the facts, evidence, and reasons stated in the Fifth Information for the Court CIA evidence filed February 21, 2020, and attached exhibits are incorporated by reference in this objection as if set forth fully in this objection herein. 7. For all the facts, evidence, and reasons stated in the motion to recuse, filed on February 12th of 2020, are incorporated by reference in this objection as if set forth fully in this objection herein. 8. For the defendant, James Corey Goode, being legally and lawfully contractually obligated to pay plaintiff the amount claimed, approximately $70,000 plus any and all legal fees incurred, and otherwise expenses or damages incurred being awarded to plaintiff for the semblance of any impedance of remedy due to plaintiff, petitioner, by defendant, respondent, and or those who may represent him even up to $10 million, such as performing avoidance and evasion, opening fraudulent and malicious prosecution cases, and plaintiff enduring ongoing public harassment, defamation, and stalking, all is set forth in the unrebutted presumptive prima facie evidence in the case pre-litigation affidavit complaint agreement first dated April 18th of 2018, and subsequent legally binding contractual financial obligation negotiable instrument mailings, and all legally and lawfully unrebutted and due now per estopple by acquiescence. See Rule 301, Presumptions in Civil Cases Generally. See June 25, 2018, plaintiff filed Exhibits A to H, contractual agreements and notices of failure to perform, and see November 13, 2018, amended complaint attached full presumptive pre-litigation affidavit complaint agreement and associated mailings, and as lawfully received by Mesa County Clerk and Recorder Office June 7, 2018, with public reception number 2843230, 77 pages, and in particular see the Notice of Fault and Dishonor Opportunity to Cure dated May 16, 2018, and see number 9 below for greater details. In addition to the above re-referenced facts, laws, and evidence, the following also are to be duly noted again regarding why Miss Wilde, alleged Texas attorney, and now Miss Laurie, alleged Florida attorney, are to be denied any and all fees for their being complicit with Mr. Goode and his legal deceptions, public frauds, and schemes. Roman numeral 3. Mr. Goode's legal and lawful contractual obligations to plaintiff, Ms. Montalbano. 9. April 18, 2018, plaintiff began due process of law against the defendant, James Corey Goode, and served him via USPS certified mail return receipt requested. See Exhibit P, filed September 11, 2018, USPS receipts. The presumptive pre-litigation affidavit complaint, legal agreement, and associated legal financial responsibility contracts seeking remedy, attribution, and answers from the defendant that made sense with the evidence legally and lawfully presented for his response outside of litigation, along with an offer for remedy outside of litigation. Mr. Goode was notified of his legal responsibility to respond to the presumptive legal contractual mailings and the consequences of failure to respond, and that he would be held personally, legally, and lawfully liable for the full amounts claimed in any court of law and upwards to $10 million should he delay remedy in any way, and those who may represent him pursuant to estopple by acquiescence and contract laws. See CRS Title IV, Article 3, UCC Negotiable Instruments, and in particular, but not limited to, UCC 4-1-201B28 General Definition of Presumption, and Rule 301 Presumptions in Civil Cases Generally, and UCC 4-1-202 Notice Knowledge, and UCC 4-1-303A2 Course of Performance Acquiesces, and UCC 4-1-201B16 General Definitions Fault, and UCC 4-3-503B Notice of Dishonor, and UCC 4-1-305 Remedies to be liberally administered, and UCC 4-1-307 Prima facie evidence by third-party documents, and CRE Rule 902, 4, 8, and 10 Self-authenticating presumptive and prima facie evidence for admittance. See case law, Connolly v. General Construction, CO 269 U.S. 385, 391. Notification of legal responsibility is the first essential of due process of law. Also see U.S. v. Tweel, 550 F. 2D 297. Silence can only be equated with fraud where there is a legal or moral duty to speak or where an inquiry left unanswered would be intentionally misleading. See Exhibit Amended Complaint filed November 13, 2018 and all attached unrebutted, presumptive, pre-litigation affidavit complaint agreements and associated unrebutted, legal and lawful contractually binding negotiable instrument mailings, and in particular see multiple notarized certificates of service. Also see Exhibit B, First Certificate of Service dated April 18, 2018 and filed June 25, 2018. And Certified Notice of Written Correspondence dated April 18, 2018, same as Exhibit A, filed June 25th of 2018, and Certified Notice of Fault and Dishonor, Opportunity to Cure, dated May 16, 2018, same as Exhibit D, filed June 25th, 2018, and Certified Billing Statement 001 dated May 16, 2018, and Fines and Fees dated May 16, 2018, same as Exhibit K filed June 25, 2018, and Certified Billing Statement 002 dated May 28, 2018, and Notice of Default in Dishonor dated June 4, 2018, same as Exhibit E filed June 25, 2018 for Mr. Goode's contractual failures to rebut and or perform. 10. Plaintiff filed the unrebutted presumptive affidavit agreements and unrebutted negotiable instruments notarized by a third party and the legally binding contractual claims and obligations now due against Mr. Goode with the Mesa County Clerk and Recorder Office June 7, 2018. Public Reception Number 2843230. Roman numeral 4. Fraud in multiple courts, misrepresentation, and misconduct by opposing party and counsels, Rule 60b-3-4 and D3, CRPC 3.3, 4.1, 4.4, 4.5a, and 8.4. Colorado Constitution, Article 2, Section 25. Miss Wilde, Texas attorney, role in fraud. 11. Early June of 2018, Mr. Goode enlisted the help of Miss Wilde, Texas-based attorney, to avoid and evade his contractual obligations to plaintiff. Miss Wilde did not instruct Mr. Goode to address or rebut the legally binding contracts. Instead, Miss Wilde, on behalf of Mr. Goode, threatened plaintiff with criminal stalking charges, opened a malicious prosecution case, repeatedly violated due process of law to also include repeat failures to serve documents filed on multiple court records, willful delays, failed to serve summons, fabricated documents, failed to confer, and filed knowingly misleading, non-stamped documents. Thereby, Miss Wilde violated her oath of office to uphold due process of law and failed to treat the opposing party in fairness and in truthfulness along with candor toward the tribunal, and she has failed to uphold and follow the Colorado rules of professional conduct, and in particular, CRPC Rule 4.5a. Seek A lawyer shall not threaten criminal, administrative, or disciplinary charges to obtain an advantage in a civil matter, nor shall a lawyer present or participate in presenting criminal, administrative, or disciplinary charges solely to obtain an advantage in a civil matter. Yet, Miss Wilde did exactly that to help Mr. Goode avoid and evade his contractual obligations to plaintiff. See Exhibit O, filed August 30th, 2018, this court record, and filed on Federal Court Record August 31st, 2018, titled Motion for Remand for Multiple Violations of Due Process. And see Exhibit BZ, Orders, Federal Court Record at dockets 30 and 44, and see Certificate of Service, this court record for June 25, 2018, denoting certified USPS courtesy copies, this case 18 CV50 complaint, delivered June 27th of 2018 to Mr. Goode and Miss Wilde. Broomfield Combined Court Malicious Prosecution. 12. Miss Wilde knew of the pending lawsuit against Mr. Goode as early as June 5, 2018, with notification and knowledge of such pending litigation contained in the presumptive pre-litigation affidavit complaint and contractual obligation mailings, first dated April 18, 2018, and served pursuant due process of law. See Number 1 above and Exhibits I, J, and K filed June 25, 2018 by plaintiff. Instead of instructing Mr. Goode to address the legally binding contracts or provide certified proof of her authority to address the legal contracts on behalf of Mr. Goode, CRS UCC 4-1-20120 General Definitions Holder and UCC 4-3-302 Holder in due course, Miss Wilde and Mr. Goode attempted and failed to open their first stalking case claim in the Broomfield Combined Court located in Broomfield, Colorado, mid-June 2018. The clerks of Broomfield Combined Court informed plaintiff by phone mid-June that their case was rejected because they did not meet the requirements. Additionally, stalking was only ever alleged by the defendant after plaintiff sought legal remedy and attribution for Mr. Goode and his associates' unlawful use of her intellectual property and proprietary trade secret research and materials. During June of 2018, Miss Wilde was diligent in communicating with plaintiff for harassment purposes for she and Mr. Goode's first malicious prosecution case attempt. See Exhibit CA, email notice from Miss Wilde dated June 5, 2018, never opened for virus concerns, And see Exhibit L, status report filed August 13, 2018, and all emails, and in particular see June 16, 2018 and June 19, 2018 email of phone voicemail for their first stalking case attempt. 13. It was clear Mr. Goode was not going to address his contractual obligations outside of litigation. On June 25th of 2018, plaintiff opened this instant case on constitutional grounds, seeking the court to order the defendant to stop defaming plaintiff to mutual associates and peers, to stop using her intellectual property and proprietary trade secret research, and ask the court to issue injunctive relief and a summary judgment to legally declare plaintiff's approximately 500 handwritten stories emailed to the defendant during 2017 by mistaken error as legally being plaintiff's. See plaintiff filed proposed order June 25, 2018, equal to an injunctive relief request, as no monetary remedy was sought at that time. 14. Plaintiff attempted legal service of process of this instant case summons upon the defendant June 27, 2018, via Boulder County Sheriff's Office at Gaia TV, the defendant's then known place of employment. See affidavit in support of order for service by publication, attached exhibit return of unserved civil process filed July 3rd of 2018. 15. Plaintiff emailed Ms. Wilde July 1st of 2018 asking cooperation of service of Mr. Goode and perform due diligence to serve Mr. Goode the summons for this instant case. No reply was received from Ms. Wilde until July 13th, 2018. And after having just been in regular contact with Miss Wilde during she and Mr. Goode's first attempts at a malicious prosecution case during the month of June. See Exhibit CA, Email Communications, June 2018, VYW and ACM. And see Exhibit L, Status Report, all June 2018 emails, and see affidavit in support of order for service by publication, attached exhibit return of unserved civil process filed July 3, 2018, and noted lack of communication from Ms. Wilde on page 2, paragraph 2. 16. In response to plaintiff's lawsuit for contractual claims due, the defendant and Ms. Wilde avoided and evaded for at least 2 weeks proper acceptance of service of civil process of this case's summons, and instead they fabricated evidence for the Broomfield Combined Court. Mr. Goode lied on the Broomfield Court record, and they successfully opened their second attempt at a malicious prosecution case July 17, 2018. Ms. Wilde did not inform plaintiff of this second successful effort until the day prior the July 24, 2018 hearing in Broomfield, 5 hours away, and only by email. In contrast, during her first failed malicious prosecution efforts, she was in regular communication with plaintiff, and between July 13th of 2018 to July 23rd of 2018 was an additional communication with plaintiff regarding serving Mr. Goode for this instant case. See number 12 above and see attached Exhibit CA, and again see Exhibit L, Status Report filed August 13th of 2018, Email Communications, June of 2018, and in particular emails dated July 23rd, 2018 between Ms. Wilde and plaintiff. 17. Mr. Goode was ordered in the open Broomfield Combined Court hearing on July 24th of 2018 to retain a legitimate Colorado lawyer by the Honorable Magistrate Russell. Mr. Goode, however, did not retain or enter a lawful lawyer pro hac vice or otherwise onto the Broomfield Court record at any time, and he continued to write papers with Miss Wilde, a non-verified attorney who continued to harass and threaten plaintiff under color of law as if she had legal authority to represent Mr. Goode. Plaintiff will petition for the open Broomfield Court hearings and other court records should it be required. 18. Mr. Goode lied in his July 17, 2018 Broomfield Court record filings by declaring he was not aware of any stalking protection order issued against himself, when the Texas court record clearly shows He has a lifelong mutually agreed upon stalking restraining order issued against him since October 31, 2014, and that has been a matter of public issue since August 17, 2017, as reported on by investigative reporter Daniel Litz. See filed August 2, 2019, motion preliminary injunction affidavit Alyssa C. Montalbano, Exhibit AQ, Broomfield Court Fabrications, and see filed December 11, 2018, motion to set scheduling hearing, Exhibit Amended Grievance, Exhibit C, Darling International / Good Protection Order, cause number 14-04807, District Court of Dallas County, Texas, 116th Judicial District. 19. Mr. Goode lied on the Broomfield court record July 17, 2018 that he was being threatened with a lawsuit when he and his counsel clearly knew plaintiff had opened a case against him for his contractual obligations due, pursuant due process of law. Furthermore, Ms. Wilde stated by email on July 15th of 2018 that she and Mr. Goode had decided they would appear in this instant case by way of filing a motion to dismiss. See Status Report, Exhibit L, filed August 13, 2018, email dated July 15, 2018 at 12:44 p.m. at paragraph 1. On July 18th of 2018, Mr. Goode did in fact appear in this instant Mesa District civil case by way of filing a motion to dismiss, and he again denied the presumptive agreements and his legally binding contractual financial obligations to provide remedy and attribution due plaintiff pursuant his tacit agreement of estopple by acquiescence. See filed August 2, 2019, motion preliminary injunction affidavit Alyssa C. Montalbano, Exhibit AQ, Broomfield Court Fabrications, and see November 13, 2018, filed amended complaint and attached pre-litigation affidavit complaint and contractual mailings. 20. Mr. Goode lied on the Broomfield court record that plaintiff phoned him all the time when plaintiff doesn't even have his phone number, and he has clearly refused to place it on this or any other court record since June 25, 2018, per due process of law rules. See again August 2, 2019, filed Exhibit AQ. Broomfield Court Fabrications, and see all court record filings this court record with no phone number for legal conferral or otherwise placed. 21. Mr. Goode and Ms. Wilde lost their stalking claim case a second time on August 6 of 2018, and the emotionally and financially burdensome malicious prosecution case was dismissed in Ms. Montalbano's favor. See motion to set scheduling hearing filed December 11th of 2018, attached Exhibit A, Broomfield Register of Actions and Dismissal Order. 22. Ms. Wilde continued to threaten plaintiff with police, criminal, and administrative actions for mailing Mr. Goode copies of legal filings and for seeking remedy for the contractual obligations due. Ms. Wilde continued to file fabricated and misleading documents on multiple court records while assisting Mr. Goode in his avoidance and evasion tactics. See Status Report, Exhibit L, email communication dated June 27, 2018, Ms. Wilde threatening plaintiff with police action for serving the defendant copies of legal documents filed, and see attached Exhibit CA, and see again amended complaint, Exhibit Pre-Litigation Affidavit Complaint, and contractual obligations filed November 13th of 2018. And amended complaint filed August 2nd of 2019 with causes of action and statutory claim counts, and in particular claim counts 1 and 2, malicious prosecution and abuse of process. With respect to Ms. Wilde's role in the Broomfield combined court case, Ms. Wilde assisted her client, the defendant, Mr. Goode, in a malicious prosecution case twice, and used abuse of process and has forfeited her right to any fees. Since Mr. Goode clearly lied on the Broomfield court record to obtain the temporary stalking protection order in his second effort, and Ms. Wilde knew what they filed the first time did not meet the requirements, and she knowingly did not advise Mr. Goode to address the legally binding contractual obligations per due process of law, Mr. Goode and Ms. Wilde have forfeited their right to any legal fees resultant from the Broomfield case, and remedy for such unlawful delays and harassment may in fact now be awarded by this court, even upwards to $10 million to plaintiff pursuant due process of law, estopple by acquiescence, and as tacitly agreed upon by the defendant in the notice of fault and dishonor opportunity to cure dated May 16th of 2018 for any semblance of impedance of remedy due. CRS UCC 4-1-201B16 General Definitions Fault. CRS UCC 4-3-503B Notice of Dishonor. See Exhibit D, Notice of Fault and Dishonor Opportunity to Cure, dated May 16, 2018 at page 2 of 2, section titled Respondent Confession of Judgment is with these stipulations at number 2. And see Exhibit E, Notice of Default and Dishonor, dated June 4th of 2018. Both filed June 25th, 2018, this court record by plaintiff. And see legal notices and all financial contractual obligations filed in full with November 13, 2018 amended complaint as attached exhibit pre-litigation affidavit complaint and associated contractual mailings. See Exhibit CF USPS served contracts. Denver Federal Court Abuse of Process 23. After Mr. Goode and Miss Wilde's failure with a malicious prosecution case twice, Miss Wilde and Mr. Goode then performed abuse of process and went behind plaintiff's back, no conferral, and haphazardly removed this instant case to Denver Federal Court on grounds that federal law was invoked by plaintiff's claims. Now, had Mr. Goode and Miss Wilde filed plaintiff's pre-litigation affidavit complaint and associated contractual mailings, or even this court record's June 25, 2018 filed complaint documents, this would have made both legal and logical sense. 24. However, Miss Wilde then proceeded to file a fake complaint on the federal court record, and that was also falsely labeled as if plaintiff filed it, and Miss Wilde again moved to dismiss for failure to state a complaint. Miss Wilde filed papers that showed no statutes or laws whatsoever and filed a cover letter sent to Mr. Goode from plaintiff seeking to settle outside of litigation and that plaintiff never filed on any court or public record at any time as part of the legal contractual obligations due. In so filing her fake complaint at docket 26 on the federal court record, August 13th, 2018, Miss Wilde clearly violated due process of law, her oath of office to uphold such processes, and again the Colorado Rules of Professional Conduct, Rules 3.3, 4.1, 4.4, 4.5a, and 8.4. See Exhibit BZ Federal Court Record Docket 26 Fake Complaint incorrectly marked as if plaintiff filed it, and see a motion to set scheduling hearing filed December 11, 2018, attached Exhibit H Improper Complaint and Motion to Amend Document 73-1 filed 11/15/18 of Fake Complaint crossed out, and compare with this court record June 25, 2018 complaint filings, and compare with presumptive pre-litigation affidavit complaint and contractual obligation mailings filed with Mesa County Clerk and Recorder, Public Reception Number 2843230, 77 pages, and in full this court record November 13, 2018 with amended complaint. And see June 25, 2018 Certificate of Service. See Exhibit P, filed September 11, 2018 USPS receipts, denoting service of Miss Wilde and Mr. Goode, courtesy copies of this court record complaint filings via USPS certified mail and delivered June 27, 2018. 25. Plaintiff only discovered the damages of Miss Wilde's fake complaint filings when Judge Gallagher, the non-dispositive judge, filed his recommendation regarding defendant's motion to dismiss on the federal court record at docket 57, October 19th of 2018. Plaintiff still did not fully understand the scope of damages until after speaking with a lawyer kind enough to explain the problem. See Exhibit BZ, Docket 57, Recommendation. 26. Plaintiff again contacted the Denver Federal Pro Se Clinic and learned of state-level trade secret laws in CUTSA and how to more correctly cite statutory law, still not done perfectly, though better, and amended the complaint November 13, 2018 from constitutional laws to attempt to restate the issues in state court preferred statutory counts, and again seeking the same injunctive relief since June 25th of 2018 case implementation. Only now plaintiff was claiming the monetarily due contractual obligations for all the harassment and delays performed by the defendant and his Texas-based counsel, Ms. Wilde, that further impeded plaintiff's contractually agreed upon remedy due. 27. Plaintiff also learned of referring back and that she could amend a denied motion and filed a motion to amend the first denied motion for remand and now cited jurisdiction issues via referring back to the newly discovered fake complaint filed by Ms. Wilde on August 13th of 2018. Subsequently, Judge Moore, the dispositive judge who read plaintiff's filed papers and issued lawful orders based in fact, law, and evidence, granted plaintiff's amended motion for remand December 3rd of 2018. See Exhibit BZ, Docket 62, 10/26/2018, amended motion for remand, and see granted amended motion for remand orders at Docket 79 and 80, 12/3/2018, and see this court record December 5th, 2018 case reopening. Roman numeral 5. Mr. Goode, ongoing harassment since remand. 28. Since case remand December 3rd of 2018 through to current, Mr. Goode has continued to avoid and evade all efforts to confer or settle his contractually due obligations to plaintiff outside of litigation, and instead, he and his associates have continued to repeatedly and severely harass and publicly defame plaintiff, along with harassing multiple potential or actual witnesses in this instant case, all while Mr. Goode and his associates have continued to keep and use plaintiff's intellectual property and proprietary trade secret research as their own without any ramifications. See amended complaint and all other August 2nd, 2019 filings, and notably see fourth information for the court, defendant threatening potential witnesses filed February 19, 2019, and see objection to extension of time Exhibit BW filed February 21, 2020, showing again Mr. Goode's hate crime of calling plaintiff Dark Alliance due to the unlawful dismissal orders. 29. Mr. Goode has also again taken his abusive behaviors another step further since unlawful dismissal January 29, 2020, and has posted more YouTube lies about plaintiff on his YouTube channel March 2nd, 2020, in the comments section, and additional lies about many other potential witnesses. He is threatening everyone who's been publicly exposing his public cult and frauds with lawsuits. In the comments, Mr. Goode knowingly lies that plaintiff worked for Gaia TV, when plaintiff was never employed by Gaia TV as a result of Mr. Goode's fraud and defamation activities during 2017, and as cited in pre-litigation affidavit complaint, and for which this case was also originally opened seeking remedy for the resultant loss of employment. Mr. Goode has also performed so much public defamation and active threats against his former employer, Gaia TV, that they recently removed all the episodes of Cosmic Disclosure containing Mr. Goode. Plaintiff has screen captured some of the episodes cited in the pre-litigation affidavit complaint prior to this removal, and can submit them as evidence should it be required. 30. Further still, Mr. Goode has also started a website page showing the case filed legal documents, which isn't minded except for the fact that in so doing he is doxing plaintiff to his crazy cult followers in posting non-redacted documents with plaintiff's private contact information This is inappropriate for a public figure to do to a private individual, and this kind of exacerbated behavior is exactly what plaintiff has told the courts on multiple occasions would occur if the court failed to order Mr. Goode to stop his abusive behaviors, i.e. injunctive relief. This court needs to read and address all legal evidence as presented on an ongoing basis by plaintiffs since June 25, 2018, and actually do its job and issue orders in accordance with due process of law and the state and national constitutions to protect plaintiff from further abuse, especially since plaintiff has been patiently waiting for almost 2 years for both the moral and now monetary remedy and relief due. See attached Exhibit CC, Doxing and Defamation, and see Presumptive Pre-Litigation Affidavit Complaint Agreement, page 2 of 48, Courtesy Notice Stop and Desist filed November 13, 2018 with amended complaint. Roman numeral 6. Ms. Lurie, alleged Florida attorney, role in fraud. 31. All during 2019 and through to current, Mr. Goode continued to publicly harass and defame multiple potential witnesses in this case and an actual witness in this case, Ms. Ferrante, when the defendant and his more famous associate, Mr. David Wilcock, a fraud dream psychic, fraud dream teacher, and fraud dream prophet, enlisted the assistance of another attorney complicit with their public frauds and schemes, located in the state of Florida, Ms. Liz Lurie. Ms. Ferrante, a witness in this case and someone publicly exposing Mr. Goode and his close associate, Mr. David Wilcock's public frauds and schemes, forwarded to plaintiff December 22, 2019, the color of law, harassing, and defamatory email she received from Ms. Liz Lurie, dated December 17, 2019. Attached Exhibit CB, Ms. Liz Lurie provides fake law firm mailing address for legal correspondence. 32. In good faith, December 31, 2019, plaintiff wrote an affidavit and USPS certified mailed a true and correct certified copy of the legal notice to Ms. Lurie to notify her of this pending case and instructed her to stop harassing potential witnesses and noticed her of her due process of law violations, and also informed her how she may lawfully enter this instant case pro hac vice to lawfully verify her identity and authority to speak on behalf of Mr. Goode for his contractual obligations due plaintiff. Plaintiff sent the certified mailing United States Postal Service using the mailing address Ms. Lurie provided on her alleged law firm's company letterhead as seen in the alleged legal email notice sent to Ms. Ferrante on December 17, 2019. Ms. Lurie's alleged signature also appears to be copy and pasted onto the emailed letter, suggesting Ms. Lurie may not be the actual Ms. Liz Lurie. As a courtesy, a copy of this notarized affidavit notice was emailed to the defendant, James Corey Goode, the same day it was deposited with the United States Post Office for lawful service upon Ms. Lurie, December 31, 2019. See Exhibit CB, Ms. Liz Lurie, fake law firm address, and Mr. Goode emailed a courtesy copy of the legal notice. 33. Subsequent to the certified USPS mailing to Ms. Lurie about January 6, 2020, through January 13, 2020, the United States Post Office returned the certified mailings marked as S. refused and return to sender attempted, not known, unable to forward, return to sender, showing Ms. Lurie knowingly provided a fake address for legal correspondence. See Exhibit CB, Ms. Liz Lurie, fake law firm address, and USPS return to sender. 34. Additionally, it is to be duly noted as further evidence that Ms. Lurie knowingly provided an improper address for legal correspondence under color of law to threaten Ms. Ferrante, the address now provided to this court by alleged Ms. Lurie for her alleged legal fees due in the amount of $1,050 is a different address than that given on her alleged law firm's office letterhead for legal correspondence. See defendant filed on or about February 26, 2020 document titled LL Legal PLLC and compare it with Exhibit CB Liz Lurie fake law firm address and USPS return to sender. 35. Ms. Lurie clearly provided a fake mailing address for legal correspondence and or she was instructed to refuse the legal correspondence by Mr. Goode, who received a courtesy copy the same date of mailing, December 31, 2019. Regardless, Ms. Lurie has shown herself to be another dishonest and complicit, improper, out-of-Colorado state attorney assisting Mr. Goode in avoiding and evading his legally due contractual obligations to plaintiff. And she is assisting in efforts to conceal his public frauds and schemes through harassment and coercion of innocent people, publicly exposing Mr. Goode and his associates' public fraud through the use of color of law. Ms. Lurie has clearly violated due process of law and her oath of office to the Constitution of the United States of America to uphold such processes, along with the Colorado Rules of Professional Conduct, notably Rules 3.3, 4.1, 4.4, 4.5a, and 8.4, and has forfeited her right to any fees. Ms. Lurie, having harassed and threatened Ms. Ferrante, a witness in this case under color of law, through and having provided Ms. Ferrante and by extension plaintiff with a knowingly false address for legal correspondence, has forfeited her right to any legal fees. Constitution of the United States of America, 14th Amendment, Sections 3 and 4, and Colorado Constitution, Article 2, Bill of Rights, Section 9 and 25, and Article 12, Section 10. 36. Therefore, it is clear that both Ms. Wilde and Ms. Lurie, alleged attorneys for the defendant, Mr. Goode, have not followed due process of law or the Colorado Rules of Professional Conduct pursuant their oath of office to the state and national constitutions, and have, in material fact, assisted Mr. Goode in his public frauds and schemes through abuse of process, malicious prosecution, and have been partisan to placing a fraud upon the court, along with Mr. Goode, and therefore have forfeited their rights to any attorney fees pursuant their oath of office and due process of law. Roman numeral 7. Failure by Ms. Wilde to lawfully enter this Mesa District civil case pro hac vice. 37. Additionally, Ms. Wilde has failed to lawfully enter this court case pro hac vice since date of first implementation, June 25, 2018, and she has failed to address any of the contractual obligations due on this court record on behalf of her client, Mr. Goode. Yet, Ms. Wilde alleged on September 7, 2018, on the federal court record to Judge Moore that she had a pending application with the Colorado Bar and implied she would lawfully enter this state court case. See Objection to Extension of Time, Exhibit BX, page 5 of 8, filed February 21, 2020. As of the date of this objection filing, Ms. Wilde still has not lawfully entered this case pro hac vice or provided satisfactory proof of authority and remains a third party that is of no use to the contractual matters at issue, and she has instead used abusive process to avoid and evade lawfully entering this case altogether and lawfully represent Mr. Goode for his contractual obligations now due. See RCP 205.3 and 205.4. Since December 3, 2018 case remand, and all during the time of non-pro hac vice entry, Ms. Wilde has failed to confer and or instruct Mr. Goode, pro se defendant, to confer with plaintiff, and she has consistently failed to follow due process of law and has further perjured her oath of office to uphold such processes and thereby has forfeited her right to any attorney fees, this case devoid due process. Because Ms. Wilde has also shown she is willing to deceive the courts, judges, and plaintiff with fabricated documents and fabricated or knowingly misleading evidence to support the defendant's public frauds and schemes, her word, affidavits, or affirmations on court records have proven to be invalid, and she has vacated her office and has forfeited her right to any fees pursuant her oath of office and due process of law. Constitution of the United States of America, 14th Amendment, Sections 3 and 4, and Colorado Constitution, Article 2, Bill of Rights, Section 9 and 25, and Article 12, Section 10. Roman numeral number 8. Defendant Mr. Goode, mental health issues of dementia, CPTSD, aphasia, and brain trauma need to be investigated. 38. Mr. Goode publicly claims he has dementia, aphasia, CPTSD, brain trauma, and epilepsy. Mr. Goode publicly behaves as someone with all the mental health disorders he publicly claims having. It is already clear Mr. Goode can't seem to remember things for his legal statements to be deemed competent on a court record about what actually occurred, as seen notably on the Broomfield court record. See numbers 18 to 22 above. 39. Mr. Goode will need a professional physical, neural, and mental health evaluation performed on him by one or more reputable Colorado doctors to determine if his mental health is the issue for his recall problems or if he is simply a pathological liar. These medical exams will also need to be performed to determine if his mental health disorders are also responsible for his alien hallucinations. See Fifth Info for the Court, CIA, notably page 36 at number 18, section titled Chart of Terms Used by Defendant Match Neuroscience, and see attached Exhibit BP, Texas Court Record Mr. Goode Mental and Health Claims, and Video Exhibit BQ for Mr. Goode's public mental illness claims, filed February 21st, 2020.
Is there a limit to how many times you could send someone back in time before certain inescapable health consequences or other things would take place?
Definitely, especially with the early technologies. Such high electromagnetic fields are used that even when people that spend 20 years in the space program, being within those high electromagnetic fields, they have a lot of side effects. Temporal dementia, different types of neurological issues, weird numbness. There are a number of issues that occur from being inside those magnetic fields. So, yes, if you're sent in using the technology, especially that they used to use a long time ago, sending you back in time over and over would be like being on working in the engine room of one of these torsion drives. It's, they wear these Faraday suits that are like a metal mesh that go all the way over them when they're in these, So, yeah, it's very detrimental to the neurological system.
So is there any contraindications for people's lifespan if they've been in the secret space program?
Yes. Usually the people that have either retired or have gone through a 20 and back like myself, they have a lot of neurological issues for a while. Their quality of life tends to go down, 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 and they do not have the life expectancy as the rest of the population. That's a trade-off that they make, and most of them knowingly make that trade-off.
One of the things we described in a previous update is that you have had new information come your way about there having been more than one 20 and back program. So how does this new knowledge impact the question that's going on here, which is there a limit to how many times somebody could be sent back in time?
Yes, that information was relayed to me through Gonzalez when I was up getting an examination on the Mayan craft. And they had actually repressed those two of the 20 and back memories from me when they first met me. Because when I had the eye surgery, when I had a detached retina that they said was basically the same as astronaut's eye, I had full recall of all 3 20 and backs, and I was almost suicidal. It was bad. And then they came and assisted me by removing some of my emotional energy to some of the memories of this 20 and back, and then rebury the memories of the other two. The memories were not conducive to me having a normal life.
So given that you are a person who now believes that you've had 3 20 and backs, that would make you, I guess, with a soul age of like 105 or something like this?
Yeah, something like that.
So how does that affect you in terms of your health and your functionality?
It's definitely had side effects. I've had a number of surgeries because of neurological issues with my hands and forearms, which is common. I'm starting to have issues with memory recall a little bit, having, aphasia, where you like, all of a sudden you can't remember your normal words out of your lexicon. It's like it's been erased.
Sure.
So yeah, there are a lot of different side effects that I'm dealing with currently.
Are you aware of anyone having had 4 or 5 or more 20 and back experiences? Does that ever happen?
I'm not aware of them, no.
So you think 3 might be as far as it ever gets pushed?
I have no idea.
Has anybody ever died from having done a 20 and back that you know of?
I know that people have died while on 20 and backs, but I have not known of anyone that has died in the process of the 20 and back, the pharmaceutical process or the temporal process. Now, I'm sure in the beginning, when they were developing this technology that was passed on to us by non-terrestrials, they definitely broke a few eggs before they got the omelet right.
How do they handle it when somebody dies in a 20 and back? How do they bring those people back?
Well, if they're military, and depending on the situation, they'll receive military honors. But if they're a civilian on the 20 and back, they become a missing person.
So you can't age regress a dead body?
You know, they could probably go through the process of cloning a body at the right age and then replacing it there. So, but it really what occurs is that there's nothing to return home in that time period of the return, so you don't get returned home. And parents come in the next day, you're gone, missing person.
Do we know which extraterrestrial group gave us this 20 and back age regression technology? Was it the Draco? Was it the Anshar? Do we have any idea how the space program got this?
We got a lot of our stuff from a Nordic group.
Oh, really?
Yes.
40. Mr. Goode will also need to provide this court with legal records of his military, MK Ultra, and MyLab program training in order to determine and verify if his mental illnesses and publicly inappropriate and highly abusive behaviors and dream state interactions with plaintiff and his deceptive trade practices and theft of plaintiff's trade secret intellectual property materials are a result of and or ongoing part of the illicit mind control programs he claims being in. And if he is continuously spreading disinfo, fake news, and illicit propaganda due to being mind controlled, and or if he is just a dementia patient famous for his bluebird and alien hallucinations, and or if he is just an elaborate con man and pathological liar. Roman numeral 9. Direct objections to motion for attorney's fees and request for hearing and motion for attorney's fees. 41. Ms. Wilde states a motion for attorney's fees and request for hearing on page 3, paragraph 2, which appears to be a duplicate filing with the second motion being titled Motion for Attorney's Fees, seek. Plaintiff persisted in filing voluminous documents amounting to hundreds of pages each, see Exhibit A and B here too, with made-up law, wholly inapplicable cites to existing statutes and case law, and inaccurate statements and unrelated information. The rebuttal to this is simple. Plaintiff did not attend law school. There is no pro se clinic help in Grand Junction or anywhere nearby for plaintiff's ridiculously complex civil case that appears to involve matters of national security, and most lawyers typically don't want to work for free. Being such an unusual and exceedingly complex case for someone having to learn law on the fly and having to deal with a dishonest attorney performing regular misconduct and deceptions on and off the court record to help her client commit criminal acts, and dealing with repeat and ongoing stalking, public harassment, and avoidance and evasion tactics performed by the defendant and his associates while trying to learn court processes, plaintiff has filed many records and documents on multiple court records to tell the presiding officers, judges, and magistrates of the ongoing harassment and due process problems and asking them to make it stop and order the defendant to address the legally binding contracts while trying to learn how to communicate it in the preferred court terms of statutes and motions and learning court rules. None of plaintiff's mistakes have ever been on purpose or intentional, and none of them justify Ms. Wilde repeatedly violating her oath of office by failing to uphold due process of law and her violating contract laws instead of honorably negotiating on Mr. Goode's behalf. Colorado Constitution, Article 2, Section 1, rights originate with the people, and Section 23, right to a trial by jury, shall not be denied or abridged, and Section 25, right to due process of law. Applicable constitutional laws. 42. The basis of the case has always been the same problems: fraud and theft of intellectual property and proprietary trade secret research, ongoing defamation, stalking, and harassment, and are defined by the Colorado Constitution, Article 2, Bill of Rights, in Section 3 as the right to pursuit of happiness, i.e., not being stalked, harassed, defamed, or stolen from. Section 6, right to a speedy remedy, i.e., not waiting almost 2 years for a hearing or injunctive relief in a trial. Section 10, right to a trial by jury for matters of libel, i.e., defamation per se. Sections 14 and 15, right to protection of property from being taken and used without compensation, i.e., intellectual property, art, and proprietary trade secret research and being compensated for its use. And Sections 23 and 25, right to trial by jury and due process of law, and all as defined in August 2, 2019 amended complaint and attached filings in statutory counts and injunctive relief request. Ms. Wilde, knowing due process violations and unnecessary delays of almost 2 years, burdened both the courts and plaintiff. 43. However, Ms. Wilde, on the other hand, alleges in her request for fees, also on page 3 of her motions, in a chart at the bottom of the page, that she has been a lawyer for 8 years. Ms. Wilde, being a lawyer for almost a decade, consistently makes mistakes that any new or seasoned lawyer would conscionably know to do or not do, such as follow court rules and due process of law. Don't file a fake complaint. Don't lie on the record. Don't fabricate documents. Don't encourage your client to lie on the record. Don't open malicious prosecution cases with fabricated evidence. Don't help clients commit crimes. Don't provide knowingly misleading evidence for the court. Confer with opposing counsel. Serve copies of everything filed on the record to the opposing party for response. And serve the summons on the opposing party pursuant summons service rules, and give reasonable time and notice to opposing party to respond when you open a case. Yet Ms. Wilde has made all of these mistakes and more on a repeat and ongoing basis. It is unreasonable to think a practicing attorney of 8 years doesn't know the basics of law, legal court practices, or how to follow the rules of professional conduct. 44. Ms. Wilde further states in her motion for attorney's fees and request for hearing on page 3 that her main reason for allegedly having $115,550 in fees being requested is notably due to her work on the federal court record. However, since Ms. Wilde fraudulently removed the case from this state court to Denver federal court devoid of due process of law, amidst other due process violations, and knowingly filing a fake complaint on the federal court record, which resulted in many filings, she has forfeited her right to any of her alleged legal fees resultant from such efforts. See numbers 23 to 27 this document. 45. Ms. Wilde then repeats the same frivolous and without merit bias as seen in the January 29, 2020 orders in her mimicking the same denial of plaintiff's legally binding contracts with Mr. Goode and as publicly filed on this court record, other court records, and the Mesa Clerk and Recorder record by stating in her motion for attorney fees and request for hearing on page 2, section titled Argument and Authority, paragraph 1, Ms. Wilde states, seek. Similarly, Colorado law authorizes the recovery of attorney fees where a party or its attorney brings or defends an action that lacks substantial justification, CRS subsection 13-17-2014. According to the statute, an action lacks substantial justification if it is substantially frivolous, i.d., a claim is substantially frivolous if the proponent can present no rational argument based on the evidence of law in support of that claim or defense. 46. This instant case and claim, though highly unusual, has not been frivolous or without merit at any time, and is supported by significant amounts of legal and lawful evidence, contract law, trade secret law, notarized affidavit notices, presumptive agreements, and financial contracts that are all now legally due. In addition to these, massive amounts of evidence have been filed on this court record, other court records, and other public records showing the same repeat and ongoing harassment being performed by the defendant and his associates against plaintiff, and for which plaintiff opened this instant case June 25, 2018, seeking injunctive relief from. Due to the clearly biased order issued January 29th of 2020, devoid of due process of law, plaintiff provided even further evidence with rational explanations and legal proof of her unusual trade secret claims and rational evidence of her unusual situation with Mr. Goode in connection with the CIA mind control programs he claims being in and that must be legally investigated. C. Plaintiff filed motion to void judgment pursuant Rule 60b3, 4, and D3, attached affidavit Intangible Dream Vision DV trade secret evidence filed February 12, 2020. And also see fifth info for the court, CIA evidence, Senate hearings, CIA records, remote viewing, remote influencing, dream states, and psychokinesis research as compared to defendant public claims and plaintiff dream experiences submitted for legal investigation purposes filed February 21st of 2020. 47. Again, outside of the unusual and clearly legally provable trade secret claims, see number 5, Mr. Goode is legally contracted and financially obligated to pay plaintiff at the minimum the $70,000 claimed due through estopple by acquiescence and his tacit agreement with the unrebutted presumptive pre-litigation affidavit complaint and all associated certified financial contract mailings that continue to stand as prima facie evidence in the case and which cannot be legally or lawfully denied by any honorable court of law, as they are public record and legal evidence in accordance with due process of law and as such are not frivolous or without merit in any way and are supported by contract law and other laws. See number 9, this document, and August 2nd, 2019 amended complaint claim counts and injunctive relief requests. 48. Lastly, Miss Wilde has in fact performed and assisted in opening multiple frivolous cases and lawsuits against plaintiff on 2 different court records, Broomfield Combined Court and Denver Federal Court, and by and through her own acts and in accordance with the statute she just cited, CRS 13-17-2014, she and Mr. Goode are clearly liable to plaintiff for such remedy. Her client, the defendant, Mr. Goode, has already agreed to pay plaintiff damages for such nefarious and frivolous actions taken against plaintiff by himself or anyone who may represent him in any semblance of impedance of plaintiff's remedy, even up to an amount of $10 million without any argument, pursuant estopple by acquiescence and pursuant CRS Title IV UCC Uniform Commercial Code contract laws. Again, see number 9 this document, and again see Exhibit D, filed June 25, 2018, Notice of Fault and Dishonor at page 2 of 2, sections on default and respondent contractual obligations. Roman numeral 10, Mr. Goode, perjury on court records. 49. Additionally, given that Mr. Goode can't seem to remember, he has a mutually agreed upon stalking protection order with the District Court of Dallas County, Texas, for his papers filed on the Broomfield Court record July 17, 2018, and that he can't remember plaintiff doesn't have his phone number to make all those alleged phone calls to him, and because he also couldn't remember, a lawsuit had already been opened against him while filing his Broomfield Court affidavit papers for his stalking claims when he and Miss Wilde had agreed they would appear by way of filing a motion to dismiss just prior that, see number 10 through 12 above, it is clear that Mr. Goode likely also can't remember what he's paid or not paid to his alleged non-verified attorneys, Ms. Wilde and Ms. Laurie, in his affidavit in support of defendant's motion for attorney's fees filed on or about February 26, 2020. And it is clear both Ms. Wilde and Ms. Laurie will also fabricate documents, fabricate evidence for court, and lie to assist Mr. Goode in his frauds and schemes. Therefore, Mr. Goode's request is to be denied, and instead a medical health evaluation is to be ordered to be performed on Mr. Goode to determine his level of competence. 50. Additionally, if any fees were even remotely due, which clearly they are not, Mr. Goode, Ms. Wilde, and Ms. Laurie are all clearly willing to lie off and on court records and deceive judges and opposing counsel, and will readily violate due process of law, perjure themselves, and fabricate evidence at the drop of a hat. Therefore, none of them can be trusted to tell the truth about any alleged fees due either, and a forensic accounting would need to be performed, whereby actual certified bank statements of payments made and billing statements with a detailed accounting of how the time was spent and that legitimate attorneys do would need to be submitted on this court record to prove they aren't all lying. Again, these billing and bank statements would also need to be email dated and subpoenaed from the bank or email provider, or postmarked stamp dated from June 2018 through to the on or about February 25, 2020 fee request filings, as none of them can be taken at their word, not even under oath. 51. Mr. Goode, having perjured himself, notably on the Broomfield Court record, to open a malicious prosecution stalking case rather than address his legally binding contractual obligations to pay plaintiff approximately $70,000 per estopple by acquiescence for his use of plaintiff's intellectual property and proprietary trade secret research materials, notably during 2017, see number 9, and for his repeat and ongoing harassment and defamation per se activities to avoid and evade his contractual obligations now due 2017 through to current, Mr. Goode has forfeited his right to any legal or otherwise fees. Plaintiff requests and demands due process rights. 52. Plaintiff again respectfully requests and demands that this court and all presiding officers follow due process of law, pursuant an oath of office to the state and national constitutions, and in so doing the presiding officer must deny any and all legal or otherwise fees to the defendant and his two complicit out-of-state unethical counsels, and is to order Mr. Goode, like the Broomfield Combined Court Honorable Magistrate Russell ordered him on July 24th, 2018, to retain a legitimate Colorado lawyer for entry onto this court record, ideally one whom will follow due process of law and will morally, lawfully, and ethically negotiate with plaintiff on behalf of the defendant for his contractual obligations now due through to resolution of all matters at issue. Roman numeral 11. Court delays and lack of due process interaction with the case causing continuous and severe damage to plaintiff. Additionally, this court's severe lack of interaction and/or bias against this complex case and subject matter of the legally binding contracts between the defendant, Mr. Goode, and plaintiff, Ms. Montalbano, and the factual evidence provided since June 25, 2018, showing likely involvement of covert and illicit CIA mind control programs and clearly showing the legal involvement of plaintiff's dream research and the court's repeat failures to follow due process of law, court rules, and/or issue orders in a timely fashion, and notably to include denying plaintiff's right to a speedy trial, Colorado Constitution, Article 2, Sections 6 and 25, and the presiding judicial officer's repeat failure to set an injunctive relief hearing on behalf of plaintiff, see denied or ignored records, proposed order filed June 25, 2018, equal to injunctive relief request, and various motions to set hearings or jury demands filed on December 11, 2018, February 27, 2019, June 10, 2019, November 1, 2019, January 3, 2020, January 22, 2020, and February 12, 2020. And Judge Flynn's repeat failure to enter legal discovery have all directly resulted in the extensive amounts of legal filings like this one on this and the other two court records, Broomfield Combined Court and Denver Federal Court, all due to the ongoing abuse, harassment, stalking, and defamation being performed by the defendant and his associates against plaintiff, and the ongoing abusive process by Mr. Goode's counsels performed against plaintiff for the duration of almost 2 years now, has resulted in plaintiff's repeat efforts to get the court to perform their judicial duties, follow due process of law, and order the defendant to stop his abusive behaviors and address his legally binding contracts due plaintiff and other injunctive relief issues at claim. Severe personal and professional damages to plaintiff due to unnecessary and ongoing court delays. Plaintiff has now lost approximately 2 additional years to the already legally disputed year of 2017 of valuable time and money that should have been used to promote her art and art galleries, her written works, and self-published books. Instead, plaintiff has had to use most all of what seed investment money she had left for the past 2 years to just survive, as seen in the Three Idiots dream. See motion to void judgment, affidavit, and tangible dream vision DV trade secret evidence at page 13 of 44, number 9, and exhibit BB DV sample 9. While dealing with legal fees to lawyers, ongoing legal research, and legal mailing expenses, and covering the cost of living while spending most every day researching and writing legal papers instead of spending time with friends and family, investing in growing her business and professional relationships, or developing her dream teaching materials with her contracted associate, all while watching the defendant, James Corey Goode, and his associates continue to profiteer off of plaintiff's intellectual property and proprietary trade secret research that is highly coveted by national security intelligence interests like the CIA and, even more simply, the media entertainment industry by using plaintiff's intellectual property for stories, derivative works, print and broadcast mediums. Third malicious prosecution attempt. 55. Lastly, on March 13, 2020, due to the delays by this court and the improper dismissal orders issued January 29, 2020, plaintiff is again enduring even worse harassment from the defendant and his defamation team. Mr. Goode, Ms. Wilde, and now Ms. Laree have all teamed up and lied extensively a third time for the Broomfield court record in a third malicious prosecution case attempt against plaintiff. The following are more lies by Mr. Goode, Ms. Wilde, and Ms. Laree on the Broomfield Combined Court record. Their unlawful and ongoing harassment is very distressing to plaintiff and must stop. Plaintiff beseeches this court to please make it stop. Their unlawful acts repeatedly burden plaintiff, this court, and the Broomfield Combined Courts, and has added 7 pages to this objection. See Exhibit CG, 3rd Broomfield Unlawful Stalking Protection Order Attempt. A. Mr. Goode lies again. He is unaware of his own protection order. See Exhibit CG, Verified Motion for Civil Protection Order Number 4, Letter D. And again, see filed December 11th of 2018 Motion to Set Scheduling Hearing, Exhibit Amended Grievance, Exhibit C, Darling International / Good Protection Order, Cause Number 14-04807, District Court of Dallas County, Texas, 116th Judicial District. B. Mr. Goode places plaintiff's private home address on the papers. This is not appropriate because Mr. Goode publicly doxes people he wants his voluminous cult followers to harass at their private place of residence or business. Many witnesses can be subpoenaed to testify. And he's threatened to escalate his hate campaigns again against plaintiff and by extension her family by releasing more of plaintiff's private information publicly. See Exhibit CG, Verified Motion for Civil Protection Order, redacted for privacy, and see number 30 this document. C. Mr. Goode also lies he received his preliminary stalking protection order respectively June of 2018 and that it was then granted in July of 2018 and that plaintiff retaliated by opening a lawsuit June 25th of 2018. This situation with factual evidence showing plaintiff followed due process of law pre-litigation since April of 2018 was addressed in numbers 8 to 22 this document and shows that Mr. Goode and Ms. Wilde in fact retaliated with malicious prosecutions and failed in June of 2018 because they did not meet the requirements. Then they lied at least 3 times to open the second case on July 17th of 2018 rather than address Mr. Goode's contractual obligations due plaintiff. See Exhibit CG, Verified Motion for Civil Protection Order Number 2, and brief accompanying verified complaint for protection order and temporary restraining order at Number 2. And see the unrebutted pre-litigation affidavit complaint filed in full November 13th of 2018 of contractual obligations due plaintiff pursuant estopple by acquiescence. D. Mr. Goode then states being harassed and barraged with highly voluminous filings from the lawsuits. This was addressed in Section 4, Fraud in Multiple Courts, Misconduct by Opposing Party and Counsels this document. Also see Sections 5, 6, 7, and 8, showing the filings were due to Mr. Goode and his associates' ongoing public harassment and defamation activities against plaintiff, and due to he and his attorneys' many violations of due process of law and lying on court records, just like now. This burdens both the courts and plaintiff with having to rebut a lot of lies with facts, law, and evidence. See Exhibit CG, Verified Motion for Civil Protection Order at Number 2. E. Next, Mr. Goode lies that plaintiff has obtained his personal and confidential employment documents and has been publishing them all over the internet. Plaintiff has never even seen any of Mr. Goode's employment records or documents, let alone publish them anywhere. And plaintiff is seeking to subpoena his employment records during discovery to see if he's actually been in the CIA, MKUltra, and MyLab brainwashing and personality splitting programs he claims, along with needing to see his alleged military records and if he's an ongoing victim of the mind control programs. His bad behaviors, like now, indicate a yes, but the records will need to be seen to verify exactly what is true, or if he's just a really far out there famous dementia patient hallucinating aliens and his very inappropriate social behaviors, lying and harassing due to his mental health issues. See Exhibit CG, Verified Motion for Civil Protection Order at Number 2. and see Section 8, Mr. Goode, mental health issues, this document. F. Then they again do what they did prior and inform plaintiff of Mr. Goode's coming events and demand plaintiff be ordered to not attend. Again, plaintiff was unaware of these events, let alone going to attend. Plaintiff is seeking to put a stop to these public deceptions and frauds, not fund them. See Exhibit CG, verified motion for civil protection order at number 7, letter I, and see Exhibit L, email VYW and ACM dated June 16, 2018 at 12:34 a.m. titled Motion for Protective Order, Goode/Montalbano. G. In their Broomfield court paper titled Brief Accompanying Verified Complaint for Protection Order and Temporary Restraining Order on pages 6 and 7, they bring up Magistrate Gallagher's federal court recommendations for dismissal and his derogatory statement about plaintiff based on the fake complaint they filed. This situation was already addressed more fully in numbers 23 to 27 of this document. H. Then they lie repeatedly that plaintiff is threatening the defendant and his family. This has never occurred at any time. Plaintiff has no desire to fight or harm anyone, let alone Mr. Goode or his family, not even with how awful they've all been to plaintiff since 2018. It's been difficult enough just trying to complain about it all, obviously. See Exhibit CG, brief accompanying verified complaint for protection order and temporary restraining order at page 4. I. In the brief accompanying verified complaint for protection order and temporary restraining order on page 6, Ms. Wilde again falsely states plaintiff claims are baseless in nature. Plaintiff has shown her claims are with merit and in accordance with due process of law, the constitutions, contract laws, and that Ms. Wilde and Mr. Goode are the ones filing multiple baseless and malicious cases completely devoid of due process of law. See numbers 3 to 6, 8 to 27, 31 to 37, and 41 to 51 this document. J. In Ms. Wilde's vexful protection order email to plaintiff, Ms. Wilde demands that plaintiff is not to publicly talk about Mr. Goode and is again trying to coerce plaintiff under color of law to take away plaintiff's right to the freedom of speech, i.e. telling the truth about Mr. Goode publicly, who is a public figure, telling massive lies about aliens and the secret space program to steal innocent people's money and resources. Ms. Wilde's abuse of the legal system and of plaintiff must be ordered to stop. See Exhibit CG email from VYW to ACM dated March 13, 2020. K. There are many, many more lies and fabrications by Mr. Goode, Ms. Wilde, and Ms. Laree in this third malicious prosecution effort. However, to spare everyone from this objection being any longer, plaintiff is stopping with citing just these few and points out for this record if plaintiff was actually stalking Mr. Goode, he wouldn't need to tell lies for court records, as he would just provide the evidence. The complete filings of this third vexatious case will be submitted on this record should it be requested. Plaintiff again urges this court to please void the judgment, accept the August 2, 2019 amended complaint, and set an injunctive relief hearing immediately on behalf of plaintiff, so that plaintiff does not have to drive to Broomfield again, especially during all the coronavirus issues, as plaintiff's father, whom she lives with, is considered in the high-risk group and has a delicate medical situation, and plaintiff is staying away from social situations for the health and safety of her family and herself. It also would not be proper for plaintiff to have to drive to Broomfield for a third malicious prosecution case and defend against all the lies Mr. Goode, Ms. Wilde, and now Ms. Laree have placed on the Broomfield court record, if they manage to successfully open it again. Alleged case 2020 C32. It is clear their oaths to the constitutions and telling the truth on court records means absolutely nothing to them, and their bad behaviors need to be court ordered to stop. Plaintiff is very tired of being harassed with color of law by Mr. Goode and his improper out-of-state attorneys and being defamed by Mr. Goode and his associates. This court needs to honor due process of law, and the presiding officer needs to issue injunctive relief immediately on behalf of plaintiff to protect her from the further abuse and lies of the defendant, his counsel, and associates, and have them lawfully argue whatever they will on this court record. This entire situation causes plaintiff severe amounts of ongoing anxiety and distress since early 2018, and it is urgent now for plaintiff's personal and professional safety and emotional health that her case and claims be lawfully heard in accordance with due process of law and moved into the discovery phases. Roman numeral 12. Conclusion. Wherefore, for all the aforementioned facts, reasons, evidence, and law, and for the dismissal order issued January 29, 2020, having been shown to have been issued completely devoid of due process of law, and as being in direct opposition to the presiding officer's oath of office to the state and national constitutions to uphold said rights and processes, and thereby being rendered void, and plaintiff having shown the defendant James Corey Goode is legally and lawfully contracted with plaintiff Alyssa Montalbano, and that he is under legal obligation to pay, perform, all remedy as cited due, pursuant his tacit agreement and estopple by acquiescence since April 18th of 2018, CRS Title IV, Article 3, UCC, and plaintiff having shown the defendant's attorneys have performed abusive process and been party to malicious prosecutions and have repeatedly violated due process of law and their oath of office in multiple unlawful efforts to assist the defendant in fraud and avoidance and evasion of his contractual obligations now due plaintiff, the defendant's motion for attorney fees and request for hearing and motion for attorney's fees filed on or about February 26, 2020, and affidavits in support thereof are to be denied, pursuant Rule 60b-3-4 and D3, and for violations of an oath of office to the Constitution of the United States of America, and for attorney misconduct and fraud, CRPC Rules 3.3, 4.1, 4.4, 4.5a, and 8.4, and for willful failure to follow due process of law. Injunctive relief is to be immediately granted to plaintiff, and the courts are to lawfully award plaintiff all remedy legally due pursuant due process of law, contract laws, and other laws, and for defendant's willful and repeat failure to respond or plead his case. Colorado Constitution, Article 2, Sections 3, 6, 9, 10, 14, 15, 23, 25, and Article 12, Section 10, Constitution of the United States of America, 14th Amendment, Sections 3 and 4. Respectfully submitted, all rights reserved, Plaintiff Alyssa Montalbano, American citizen.